refer to that provisions and let us move forward. Thank you.
But let it come on record that this is the first time in which, on a matter of extreme national importance, we've been given 1 hour to be able to do an application, submit, and come back to court. We have tried to do the best that we could in terms of complying with those directions. Of course, one of the issues that we could not be able to do is that the written application could not be able to do full justice to the instructions that we've been given and to our case. And therefore, my Lord, when Professor Gedu Muigai stands senior counsel to say that we need to be gagged on the issue of time, we protest. We shall require sufficient time. This sufficient time is not forever. This sufficient time, at least for purposes of the three, presenting the one that application, is 1 hour. It is the least that people deserve in an application of this nature. Secondary issue, my Lord, is the issues of consolidation. Those issues of consolidation are as different as UDA can be from Jubilee. And the issue is, for purposes of the difference, the application under Article 165, and we did not hear you talk about the inclusion, because we've had to include. There are earlier complaint in the morning.
I'm sorry to say this.
I have.
Yes, I want to interject. If my learned friend is appealing against your orders, then there is the right one. My lord and my lady teacher.
There is no, I'm responding to what has happened. Let us be fair to each other. And my lord, what I'm saying is this, that for purposes of those applications, the application under Article 165, because in the morning when we raised the issue orally, the questions that was raised, you are raising issues against the Deputy Chief Justice, who is not a party. She is a party now, and we have served her. We took the application on the issues of the constitutional violations regarding the empanelment of this bench. We shall need the court's directions on that issue. And we've gone through the authorities within the short period that we were here. So we are standing on solid grounds. We just need sufficient time to do our business. Issue number 2, my lord, if that applications were to succeed, then it would effectively mean, as my learned colleague Mr. Ngoya had indicated, that then the issue of recusal of your lordship becomes academic. But if your lordships were to hold that all these serious injustices that the petitioners alleged were committed by the Deputy Chief Justice King, then we shall now address you, the issues that concerns you. And I need to add, on the issues of authorities, because now we've been told instructions. When we came here, we thought that while we were proceeding and actions, prepare the team in the office, let them prepare authorities to argue on the issue of recusal. When you were given 1 hour, we told them, oh, stop on the issues of recusal, now we are dealing with another thing. So, my lord, we cannot be able to argue, if it is today, we cannot be able to argue, as expected by our client, on the question of recusal. And there is no similarity of issues. Therefore, my lord, I urge you that let us adopt fair procedure. This fair procedure has
is there a specific application for recusal?
There are 2 applications.
Where are they?
At least I know, Gachagua will mention one. We are actually bringing them, even one of them in number 015 is an application dated, I believe, yesterday, 21st of October. There is another one.
Okay, this
Yes, my lord.
these are the directions we are looking. We'll deal with the application before us. The application for empanelment of this bench
Can I have application of next year?
And perhaps my Lord, perhaps before you give the directions, with my Lord, immortal, she's informing me that she was not aware of the elections in the morning, that applications be filed and we come back before you, and now her petition has been integrated in the consolidated petition, that is petition number E013. Therefore, she's not been able to file an application either for recusal or for challenging the panel. She was just requesting if she can be served with those applications and the responses, and she be given time, 1 hour just like the others, to file her real application if she wishes. Because now she's participating in the proceedings. Council, listen to this and listen to this very carefully. All of us acknowledge the momentous import of the proceedings before us. And all of us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will not be taken round in circles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue our matters. We want everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the course in cycle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with is an application dated 22nd of October 2024 by Jindo Matiba and Company Advocates. It seeks orders under Rule 3 of the Constitution. We are dealing with the issue of empanelment. And then after that, we'll look at ruling for the way forward. So let us proceed. Let us be courteous to each other. Let us be courteous to the parties before us. Parties before us are very okay, but let's not be a theater by advocates to derail the process. I beg you. On the issue of time allocation,